Today, March 14th, 2026, a government disclosure document filed just 11 days ago has confirmed something that's been the subject of speculation for months. And the details are worth walking through carefully because they tell a story that goes well beyond politics. Here's what we know. Back in July of 2025, California's governor sat down for a televised interview and was presented with a gift, a California compliant Sig Sauer pistol. After receiving it, he told the audience, and I'm quoting directly here, "I'm not anti gun at all." That line circulated widely at the time, but what happened to that firearm afterward has been unclear until now. On March 3rd, 2026, a statement of economic interest was filed with the state of California. This is a standard annual disclosure that every sitting governor is required to submit by law to maintain compliance with state ethics rules. It documents all gifts received, all trips taken, and any income earned outside of the official salary. When you pull up Schedule D of that filing, the section covering income and gifts, the Sig Sauer pistol appears. That means he formally accepted it and claimed it on the record. But scroll to the notes at the bottom of that entry, and it gets more specific. According to the filing, he reimbursed Sig Sauer for the amount of the gift that exceeded $600 out of his own pocket. Under California law, $600 is the maximum value of a gift that a state official can accept without paying the difference. So if the firearm's value exceeded that threshold, he was legally required to cover the gap himself if he intended to keep it. According to this document, that's exactly what he did. And yet, 8 months after that interview, the gun is not in his possession. The filing notes it is currently being held by a licensed firearm dealer. That's the part worth paying attention to. If you want the full picture of just how layered California's firearms acquisition process has become, check our previous video where we broke down SB 2 in detail. The law that added 16 hours of mandatory training, a mental health evaluation, and new sensitive place restrictions. And just this past week, we covered SB 948, a bill currently heading to committee that would replace the existing written test with an 8-hour in-person training course, including a mandatory live fire component. The regulatory framework around firearms in that state has been expanding consistently over the past several years. Now, here's the specific process that applies in this case. Before any California resident, regardless of title or position, can take possession of a firearm from a licensed dealer, there are several required steps. First, you need a valid firearm safety certificate known as an FSC. That requires passing a written test with a minimum score of 75%. There are no exemptions for elected officials. Then comes the DROs, the dealer's record of sale, a California-specific transaction form that must be submitted to the State Department of Justice. A thumbprint is required as part of that process. A federal 4473 form must also be completed, which initiates the background check through the NICS system. And then there is the mandatory waiting period, 10 days under California law, though in practice it typically runs 11 days because the clock runs to the exact minute of purchase, and dealer hours rarely line up to the hour. After all of that, California also requires the buyer to demonstrate that they can safely handle, manipulate, and operate the specific firearms controls. That demonstration must be done in person at the dealer. There are no alternatives, no remote options, and no exceptions based on who you are or what office you hold. If this is his first time going through this process, which based on available reporting it appears to be, then all of it applies from the beginning. If you're someone who has done this before, these are familiar steps. You've navigated them. They're time-consuming, and they carry costs. Costs we've gone into before in previous videos, including the fees tied to SB 2 renewals and the fingerprint requirements set to expand starting September of this year. But if this is your first time, The process can be difficult to navigate, and according to a California state legislator cited in prior reporting, an attorney was reportedly hired just to make sense of it. That detail alone says a lot about the complexity of the system that's currently in place. Now, and this is important, none of what's described above constitutes a legal judgment on anyone's character, intent, or politics. What's happening here is a factual document trail. A public official accepted a firearm, paid out of pocket to comply with the state gift cap law, and that firearm remains at a licensed dealer rather than in his possession approximately 8 months after the gift was received. The reason that firearm is not transferred is, according to the public record, the state's own acquisition requirements. Whether that process eventually completes or not, the disclosure document confirms the current status, and that's what this update is based on. If you've been following the channel, and if you're keeping track of everything we've covered these past few weeks, from SB 948 to Roe vs. Bonta to the SCOTUS cases still sitting in conference, this story fits directly into the broader pattern we've been documenting. California's regulatory structure around firearms is among the most layered in the country. It applies to everyone who chooses to participate in the legal process. That part is not open to interpretation. If you're finding this kind of legal and legislative coverage useful, subscribing is the simplest way to make sure you don't miss what's coming next. And given everything that's scheduled between now and the end of this month, including the March 17th SB 948 committee hearing, the March 20th Supreme Court conference, and the March 25th Roe vs. Bonta en banc arguments in Pasadena, there's a lot still in motion. As always, everything covered here is drawn from publicly available documents and official sources. This is informational and educational content based on personal analysis of those sources. It is not legal advice, and nothing here should be treated as such. If you have a specific legal situation, the right move is to speak with a licensed attorney in your state.